Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Most immigration firms spend way too much time untangling client intake. That's why e-Immigration created intelligent form intakes. It's a multilingual, auto-translating intake experience built for immigration law. Your clients complete their questionnaire in the language they're most comfortable with. The system instantly translates everything into English, flags missing information, and sends the data straight into your case file and forms. If you want an intake process that reduces confusion and increases connection, check out Intelligent Form Intakes at get.eimmigration.com, or of course, click on that special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
Hello, and yes, maybe even ho, everybody. This is Liz Montano, associate at KKTP, filling in for Kevin for the next few episodes while he enjoys some very well-earned holiday rest. Hello again to those of you who've heard me before, and hello for the first time to those who haven't. We've got a packed episode this week. 10 cases. Yes, 10, and 8 of them are from the BIA. Because apparently, the BIA did not get the memo about slowing down for the holidays. Luckily for me, Kevin was still around to cover most of the cases this week, so I'll be bookending the episode while he guides you through the middle. All right, we've got a lot to cover and not enough time for small talk, so let's get into it. First up, matter of Tepec-Garcia from the BIA. This decision answers a question I'm sure many of us have quietly wondered about for years. What happens when nobody shows up to court? And DHS also forgets to provide any evidence at all. The case is refreshingly simple, procedurally speaking. DHS issued NTAs to multiple respondents, charging them as inadmissible under INA Section 212A6AI for being present without admission or parole. The NTA set the date, time, and place of the initial hearing, and they were properly filed with the immigration court. So proceedings were properly initiated, and so far, everything is totally normal. But then, the hearing date arrives. And nobody shows up. Not the respondents, not DHS. And DHS also didn't file any evidence of alienage in advance of the hearing. No I-213, no birth records, nothing, zero, zip, nada. So the IJ is sitting there with an empty courtroom and an empty record. No respondent in sight, no DHS in sight, no evidence in sight. So what does the judge do? Well, the IJ terminates proceedings without prejudice. And then DHS appeals, arguing that the IJ erred in terminating proceedings and instead was required by regulation to continue the case and give DHS another chance to appear and provide evidence of alienage. But the BIA disagreed and held that, quote, while not necessarily required, termination is appropriate under these circumstances, end quote, pursuant to 8 CFR 1003.1 D3II. The BIA then breaks this down in a pretty clean and logical way. The BIA explained that because DHS charged the respondents with inadmissibility, DHS bears the burden to establish alienage under 8 CFR section 1240.8c. Normally, DHS meets this burden by submitting something like a Form I-213. But here, DHS submitted nothing at all. On appeal, DHS relied on 8 CFR section 1240.10d, arguing that it requires the IJ to request assignment of DHS counsel if removability is not established and DHS is not present at the hearing. In other words, DHS's position was that when DHS chooses not to appear at a scheduled hearing, and also DHS doesn't provide any evidence in advance of the hearing, the IJ must continue the case to give DHS another opportunity to show up and meet its burden. But the BIA was not persuaded. The BIA explained that Section 1240.10d, quote, has no bearing in instances where the respondents do not appear, end quote. That regulation applies only when the respondent is present, the IJ provides rights advisals, pleadings are taken, and removability is contested. But none of that happened here, nor could it have, because nobody was there. Instead, when a respondent fails to appear despite proper notice, INA Section 240b5a and 8 CFR Section 1003.26c govern. Under those provisions, the IJ must proceed with an in absentia hearing and order removal, but only if DHS establishes both proper notice and removability by clear, unequivocal, and convincing evidence. So the BIA essentially describes two different procedural worlds. World 1, the respondent appears and contests removability, during which Section 1240.10d applies. World 2, the respondent fails to appear, and INA Section 240b5a and 8 CFR Section 1003.26c apply. This case falls squarely in World 2. That means the IJ could order removal in absentia only if DHS first proved alienage by clear, unequivocal, and convincing evidence. But DHS didn't do that. The BIA even pointed out that by charging the respondents under INA Section 212A6AI, DHS knew from the outset that alienage was an issue and that it bore the burden of proof. And yet, it still failed to submit any evidence. As to DHS's argument that a continuance was required rather than termination, the BIA rejected that, noting that such a rule would, quote, impede the timely adjudication of cases in an overburdened system, end quote, because IJs would be forced to keep continuing cases and holding multiple hearings every time DHS failed to appear and failed to submit evidence of alienage. So the BIA dismissed DHS's appeal. With all that said, the BIA did emphasize that the termination was without prejudice. DHS can refile the NTAs and initiate new proceedings. And as the BIA pointedly notes, quote, if DHS elects not to appear in future proceedings that DHS itself initiated and scheduled, nothing precludes it from filing evidence of removability in advance of the hearing, end quote. So this isn't an unfixable loss for DHS. But the message from the BIA is clear. It is not the immigration judge's job to babysit DHS's case. It is DHS's job to meet the burdens that the law assigns it, either by showing up with evidence or, at the very least, filing that evidence in advance. And that is matter of Tepec-Garcia.
Starting off with the BIA, with matter of LAGB. I cannot believe that I wondered what the BIA would be doing after Loafer Bright. What a silly boy I was. The BIA has found its voice. The Attorney General certainly helped by designating this decision as precedential. This is the first of 4 BIA decisions published this week, and as of the time of this recording, it is only Tuesday. Who knows how many BIA decisions there will be this week, or if I will even do them all. Liz might do some. This decision here is about Convention Against Torture Protection overturning an immigration judge. I know. You're as astonished as I am. Mr. LAGB is from Panama and was convicted of conspiracy to distribute cocaine in America. Not granted a presidential pardon, Mr. LAGB was incarcerated and then deemed removable and ineligible for everything except cat protection. The BIA disagrees with the predictive facts found by the IJ to grant cat protection. A deferential review by the BIA, but overturned nonetheless. Quote, to determine whether a respondent has established a clear probability of future torture in the country of removal, the immigration judge must first make factual findings on what is likely to happen to the respondent if he is removed, and then determine whether what is likely to happen meets the legal definition of torture, end quote. Because, of course, broken record BIA, and by extension me, cites to matter of JFF to explain that, quote, eligibility for cat protection cannot be established by stringing together a series of suppositions if the evidence does not establish that each step in the hypothetical chain of events is more likely than not to occur, end quote. Mr. LAGB has a history of gang affiliation, and it appears that formed a basis for his cat claim. He seems to be a bit of a snitch, kind of like that case from Mexico last week. The IJ found it more likely than not that Mr. LAGB would be targeted by the King Arellano family in Panama for his perceived cooperation in the United States and by his former associate Franklin Sterling as retaliation for stealing. But the King Arellano crime family doesn't function anymore as a drug trafficking organization, explains the BIA. Plus, quote, the record does not include any objective evidence that the respondent provided any assistance to law enforcement or proffered any information about the individuals in question as part of his plea, end quote. Although given the decision last week, I don't know how much that matters anyway. Nor does the BIA see the record as supporting a retaliation belief. Really, the BIA seems concerned that all the evidence appears to be coming from Mr. LAGB's testimony itself. Nor does the BIA believe the risk of torture from other gangs in Panama specific enough to Mr. LAGB to support a cat claim. No mention whether Mr. LAGB was found credible, how detailed his testimony was, or whether that credible testimony alone can meet an applicant's burden, as of course the statute says it can. But it all means that Mr. LAGB is getting sent back, says the BIA. I don't know. Seems quite the petition for reviewable decision to me. But we'll see. And that is a matter of LAGB. Next is matter of Kim, published by the BIA. Another one that the Attorney General decided to make precedential. This decision is about discretion. Pro se non-citizen too, because why not at this point? Mr. Kim received LPR cancellation of removal. He's from South Korea, and as applicable here, all that matters is whether an IJ in the BIA believes that he warrants a second chance to keep his green card. He does not, says the BIA, overturning the IJ. He's been here since 1979. Came when he was 10 years old. Should have naturalized, but he didn't. If he had, we wouldn't be talking about him at all. But in the late 1990s, he developed a gambling addiction, and he started stealing to fuel it. Apparently, he became quite the notable thief throughout Los Angeles, according to the BIA. 14 years of scams. Quote, his favorite method was to falsely represent himself as a licensed contractor, convince victims to pay a deposit for home improvement work, and then cease contact with the victims and abscond with their money, end quote. Not gonna lie, I'd be pissed. Stole from his wife too, leading to divorce, and didn't pay taxes for 30 years. So I don't know. Kind of an outlier, guys, I'd say. He was eventually convicted for grand theft, and he lost his green card after 4 years in prison. But as apparently it wasn't deemed an aggravated felony, he was deemed eligible for LPR cancellation removal under INA Section 248A. And as I mentioned, an immigration judge granted it. He had lots of other convictions too already, 8 misdemeanors and 7 felonies according to the BIA, so not great. On the other hand, quote, the respondent testified that his most recent incarceration was a wake-up call, and he found religion and received rehabilitative care for his gambling addiction, end quote. 3 adult U.S. citizen children, and some other positive factors too, and most importantly, the IJ believed that Mr. Kim exhibited sincere remorse and had rehabilitated. So it seems to me that would be hard to vacate on appeal. That seems to be IJ fact-finding to me. Which is, of course, why the BIA didn't really try. They assume it all and weigh it against the crimes and believe it all lacking as a matter of discretion. So not clear error standard of review that if you're not overturning an IJ fact-finding, it's de novo review for discretion, to the BIA that is, weighing the facts rather than overturning a fact, and finding it all lacking as a matter of discretion. Snaky, snaky. Importantly, the BIA, though I believe uncontested and not relied on by the IJ, quote, the respondent has shown no meaningful period of time since the early 2000s when he was not systematically defrauding members of his community, the government, and or his own family, end quote. And quote, additionally, While the immigration judge was persuaded by the respondent's testimony that this most recent incarceration has truly rehabilitated him, as DHS notes, none of his previous incarcerations or rehabilitative efforts succeeded, and he did not present any specific plan for employment, support, or maintaining recovery upon release. Even if the respondent, while incarcerated, truly feels remorse for his crimes and believes that he is a changed man, we have no confidence that the respondent will not resume his long-standing pattern of criminality after release. End quote. I don't know, BIA. That doesn't sound like clear error review to me. Also doesn't sound like weighing facts. Kinda sounds like fact-finding. Kinda sounds like it. Acknowledging that he's been here a long time, but also stating that he primarily speaks with his adult children over the phone anyway, the BIA ordered Mr. Kim removed, vacating the IJ's cancellation of removal grant as a matter of discretion. And that is matter of Kim. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. Moving on to matter of Lema Mizhirumbay, published by the BIA. This is at least a unique one about discretion, which the Attorney General decided to make precedential, overturning an immigration judge. So much abuse of discretion going on these days. Who knew? Mr. Lema Mizhirumbay is from Ecuador and was granted non-LPR cancellation of removal based presumably on a finding that his U.S. citizen children, or at least one child, would suffer exceptional and extremely unusual hardship without him. No small thing, and pretty important to a grant of discretionary release. In addition to the, quote, significant equities, end quote, recognized by the BIA, is the fact that Mr. Lema Mizhirumbay is, quote, also active in his church community and serves as his church's music director, end quote. But he also has a, quote, recent criminal conviction after a prolonged refusal to address or accept responsibility for worksite safety that resulted in the death of 2 individuals, end quote. Not only that, although likely related to it, the IJ also, quote, found that the respondent's violation of regulations for the Occupational Safety and Health Administration, or OSHA, contributed to the deaths of 2 individuals who were working on roofs for his company, end quote. Seems to be based on a lack of safety equipment during roof work. And then Mr. Lema Mizhirumbay apparently willfully failed to pay OSHA fines after the first worker died. And then another died a few years later. These unique facts, surely present in literally no other case, constitute, quote, a serious adverse discretionary factor, end quote. 2 people died. Mr. Lema Mizhirumbay apparently refused to pay a fine for a while, and then he spent 4 months in prison for a related conviction. Quote, the fact that the respondent was convicted of a crime related to the willful violation of OSHA regulations further demonstrates the seriousness of his conduct, as conviction necessarily requires a culpable mental state, end quote. Given that recent criminal histories, and then I suppose lack thereof, right, are significant factors for discretion and good moral character under the Attorney General's decision matter of Castollo-Perez, the BIA weighed the facts differently than the IJ, took away Mr. Lema Mizhirumbay's cancellation of removal grant as a matter of discretion, and ordered him removed to Ecuador away from his children. Doing these pretty fast because they're not too long. And that is matter of Lema, Mizhirumbay. What else we got? Oh yes, of course, matter of NPA, published by the BIA. Another decision deemed so important that the Attorney General made it precedential. This one's about persecution. Mr. NPA is from the Soviet Union, specifically the region that is now Moldova. That's a new one for the pod. He's a citizen of Moldova, and an immigration judge granted him asylum from that country, put him on a path to a green card. Mr. NPA is specifically from the, quote, Transnistria region of Moldova, which is controlled by separatists, end quote. Police officers beat him in October 2020 while he was handing out leaflets for an anti-corruption political candidate. Then they took him to a police station and beat him some more and held him for 2.5 hours. After Russia invaded Ukraine, Mr. NPA attended protests. Then, quote, he and his son received summonses to appear for interrogation on April 12, 2024, based on allegations of calling for extremist activity, end quote. I don't know, seems scary to me. His son appeared, though, at that interrogation and was released without incident. Seems like Mr. NPA didn't attend and follow-up summonses were issued. Mr. NPA fled using his passport, and important enough to the BIA that it deems it noteworthy, quote, no government official tried to stop him, end quote. Now, the IJ granted asylum despite finding that Mr. NPA didn't suffer past persecution. Those beatings don't sound fun, though. But without a past persecution finding, quote, a respondent must demonstrate a reasonable possibility that he will be persecuted in his country of nationality, end quote. That's what makes it a well-founded fear. A question that, you guessed it, the BIA says is sufficiently legal that it reviews it de novo. And the BIA overturned the IJ, quote, the immigration judge's finding was based on the fact that the respondent was issued a pretextual summons for his political activity and on country conditions evidence showing that the separatists controlling Transnistria have detained political activists and subjected them to severe harm. However, the IJ did not properly consider the respondent's testimony that his son appeared pursuant to an identical summons and was released without incident, end quote. And Mr. NPA did remain in Moldova for several years and engaged in public political activity apparently after the beatings, notes the BIA. And he did leave freely, quote, without incident, end quote, notes the BIA. Beware of and be prepared for that last unelaborated upon sentence, asylum warriors. Seems like it might be one of those important things. And that's about it, too. Similar reasons to the BIA for denying withholding of removal and cat protection. Asylum was taken away. The BIA also notes that it generally does not consider new country condition evidence or really any evidence on appeal, like what was apparently submitted in this case on appeal. But to the extent that that means Mr. NPA was filing a motion to remand, the BIA denied that too, as the BIA believes it unlikely to change the result of the case below. And that is a matter of NPA. Next up is matter of Rodriguez-Pena, published by the BIA. And LOL, I couldn't even make it past Wednesday without the Attorney General doing it 2 more times. You know what? Screw it. Bring it on, BIA and Attorney General. I'm gonna do them all. Give me 12. I don't care. 2 a days. 3 a days. Let's do this. I can meet your crazy. I'm in. This decision, with a pro se respondent, is about bond. Mr. Rodriguez-Pena was granted a $7,500 bond. DHS appealed. The BIA notes that the respondent, who is presumably detained and doesn't have an attorney, has surprisingly, quote, not written to oppose the appeal, end quote. DHS won. Apparently, Mr. Rodriguez-Pena has been in the United States for a long time and has a bit of a criminal arrest history through many states going back to 1997, even involving Alaska. But given that all these arrests and related charges, including drug trafficking and domestic violence, were dismissed, quote, we agree with the immigration judge that these arrests are not particularly probative of his dangerousness, end quote. And that's with the last arrest in 2019, by the way. Take note. But Mr. Rodriguez-Pena was arrested again for, quote, engaging in violent and aggressive conduct directed at people in his community, end quote. Specifically, an arrest warrant alleges that he threatened to kill his friend by saying, quote, I'm going to get a gun and shoot him, end quote. A New Jersey terroristic threats charge was brought. No conviction, at least yet. Honestly, it does seem like it was dismissed. We'll get to that in a sec. Now, Mr. Rodriguez-Pena actually submitted an affidavit from the alleged victim himself, who essentially said, it's not a big deal, guys. I started it. That is the victim. And he doesn't think police were even called, but rather that all this occurred within earshot of a police station, which is quite the unfortunate coincidence for Mr. Rodriguez-Pena, if true. The immigration judge relied on this affidavit heavily, but to the BIA, the IJ failed to account for other statements in the affidavit that Mr. Rodriguez-Pena had become very upset when police arrived. To the BIA, this, quote, erratic and volatile behavior, end quote, indicates dangerousness, even without a conviction, and even if the case has been dismissed. Even if. How about that? Be careful with what you allow witnesses to put in affidavits, folks. Also, quote, threatening to kill someone over being pushed is a disproportionate response indicative of dangerousness, end quote. Okay, but genuine question, BIA. What is your opinion, hypothetically, about a president sharing a social media post suggesting that a sitting U.S. senator be hung for treason? Just curious. A disproportionate response indicative of dangerousness? Or just a forgivable overreaction? To say nothing about off-the-cuff remarks about genital grabbing or telling a domestic terrorist organization to stand by on national television? Hypothetically, of course. Pray tell, though, what does that indicate, BIA? In any event, quote, the documentary record does not contain any statement, rehabilitation evidence, or assurance from the respondent about his conduct, and his counsel's statements below are not evidence, end quote. And now really getting into it, the BIA further notes that it believes Mr. Rodriguez-Pena has made a false claim to U.S. citizenship in the past. Quote, his use of an alias to evade arrest and falsely claim citizenship demonstrates disregard for our nation's criminal and immigration laws and therefore indicates dangerousness, end quote. Okay. No letter from his spouse either in the bond proceedings, and so the BIA ordered him detained for the entirety of his removal proceedings. Here's something, though, that caught my eye. My understanding has always been that an immigration judge cannot grant a bond lower than $1,500, even if the IJ doesn't believe the non-citizen a flight risk. But I guess I was wrong. Because in a footnote, quoting 1994 precedent, the BIA states that, quote, once it is determined that a non-citizen does not present such a risk, then no bond should be required, end quote. Quoting matter of Drysdale, BIA, 1994. So cite this decision and Drysdale and go for broke with a $0 release request. Says I. And that is matter of Rodriguez-Pena. Moving on. Matter of Palma-Olvera, published by the BIA. A non-precedential made precedential decision by the Attorney General about good moral character. Pro se non-citizen. Overturning an immigration judge's grant of non-LPR cancellation of removal. This pro se respondent did file an opposition to DHS's appeal, doing his best. So, exceptional and extremely unusual hardship shown below, obviously. But among other things, to get this relief, that is non-LPR cancellation, non-citizens must show that they possessed good moral character during the last 10 years. Now, I&A Section 101F lists out good moral character bars, specific bars, but it also has a catch-all provision that essentially says that IJs can consider whatever they want. Into that exception, destined to become the rule, stepped Attorney General Barr, with matter of Castollo-Perez, holding that 2 DUI convictions within the good moral character period presumptively negates a good moral character finding. Mr. Palma-Olvera has a DWI conviction from 2022 and another from 2024. So big problem. If, of course, it was proper for the Attorney General to make a near categorical good moral character rule not outlined by statute. Under Castollo-Perez, quote, the presumption may only be overcome in an unusual case in which a non-citizen can establish that the multiple convictions were an aberration and can show good moral character, end quote. Here, the IJ believed that Mr. Palma-Olvera rebutted the presumption because he supports and is very active in the life of his U.S. citizen child who is autistic, suffers from ADHD, and has mood disorders, that is, the child, and because Mr. Palma-Olvera is gainfully employed and had good moral character witnesses testify in court. Not unusual enough, though, said the BIA. He was, after all, well above the legal limit both times, and he hit a lamppost the second time. So, he's getting removed and presumably separated from his child. And that is matter of Palma-Olvera. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Next is Sane Carrera v. Bondi, published by the Sixth Circuit on December 15, 2025. This case is about no-notice motions to reopen. Miss Herrera, as the Sixth Circuit calls her, is from Guatemala and entered the United States without authorization in the 1990s. She applied for asylum in 1997, apparently with the help of a man in Tennessee who may or may not be an attorney, listing an address in that application. Seems like instead of deciding the application, the government sent Miss Herrera a notice to appear. It contained the date of the hearing, too, which was later advanced. Miss Herrera never appeared. In 2010, she filed a motion to reopen, alleging that she had lacked notice of her hearing. The immigration judge did not deny that motion, but instead issued an order requesting additional information within 60 days. Seems to have given Miss Herrera a chance. She never responded, so the IJ denied the motion. In 2020, Miss Herrera tried again. This time, the same or a different IJ denied based on that regulation that says that individuals are only allowed one motion to reopen. Ms. Herrera appealed that to the BIA, but argued only that she didn't receive notice and that extraordinary circumstances had stood in her way of attending the hearing, which, to be honest, might be a little contradictory. She didn't challenge the one motion to reopen rule, though. The BIA dismissed the appeal and declined Ms. Herrera's request for sua sponte reopening. That is, just asking the BIA to kind of be nice because it was in the interest of justice. Ms. Herrera petitioned for review to the Sixth Circuit, where she very much challenged the IJ's finding that the no-notice motion to reopen is subject to a one-motion limitation. That rule is not set in stone for no-notice motions to reopen as I understand it. That is the one motion to reopen rule, because no-notice motions to reopen do of course implicate constitutional concerns. The problem for Ms. Herrera, though, is that she didn't brief this issue to the BIA. So the Sixth Circuit deemed the argument unexhausted and therefore unreviewable at the circuit level. To the Sixth Circuit, it seems the claim that the number bar applies to no-notice motions to reopen is too distinct to be subsumed within the other claims brought before the BIA regarding the equities of the motion to reopen, thereby requiring specific exhaustion before the agency. Not done, so no review, said the court. The Sixth Circuit went on to explain that because sua sponte reopening, the second type of reopening, is essentially at the BIA's, quote, unfettered discretion, end quote, it's not subject to judicial review, as so many circuits and even the Sixth Circuit before it have held in the past. Now, Ms. Herrera put up a fight. She argued that the Supreme Court's Loper-Bright decision changed things, such that the Sixth Circuit need not rely on its old case law on sua sponte reopening and its authority to review the BIA's denial of it. Likely the reason this decision is being made precedential, if I'm being honest. Quote, but our prior cases declining to review the BIA's sua sponte reopening decisions have not rested on deference to the BIA's reading of a statute, end quote. So the panel doesn't see a Loper-Bright issue or Loper-Bright as having changed anything. Now it is true, conceded the panel, that it may, emphasis may, be able to review a sua sponte denial where the BIA commits a legal error in denying sua sponte reopening. Such a rule would align with other circuits, including the Ninth Circuit, I believe, and while the rule does conflict with the Sixth Circuit decision, it seems like cracks are developing in the Sixth Circuit? Maybe. And this is like a situation where, I don't know, if the BIA denied sua sponte reopening based on an underlying belief that the law does not permit sua sponte reopening for Guatemalans, or a less egregious hypothetical, if the BIA denied sua sponte reopening because it believed that the law does not permit sua sponte reopening to permit non-citizens to apply for, say, discretionary release. Those would both be denials of sua sponte motions, but they'd be based on an underlying and clearly wrong legal conclusion, so may be reviewable in the Sixth Circuit, explains the panel. No matter, though, said the panel, as it doesn't see a colorable legal violation claim here. Quote, instead, the BIA opted to decline its discretionary authority in light of equitable and policy-based considerations, like Ms. Herrera's lengthy period of unlawful presence, her delay in seeking relief, and the importance of finality in the immigration system, end quote. That's just pure enforcement discretion to the Sixth Circuit. Distinguishing its decision in Sarkisov v. Bondi, episode 266, and rejecting some other arguments, the Sixth Circuit affirmed the denial of the motion to reopen. And that is Sini Carrera v. Bondi. Moving on, we have Lau v. Bondi, published by the Fifth Circuit on December 17, 2025. This case is about untimely petitions for review. Mr. Lau, pro se, filed one. Well, an untimely petition for review of the BIA's denial of a motion to reopen and motion to reconsider, received by the Fifth Circuit Clerk's Office about a week after the 30-day statutory deadline to petition for review. It used to be that would absolutely destroy a petition for review, but after the Supreme Court's Riley decision, the 30-day petition for review deadline is a claims processing rule, not a jurisdictional one. But circuits are supposed to enforce them so long as oil asserts the rule, which of course oil's always going to do, and it did here. Mr. Lau is doing his best to fight back himself, filing a, quote, flurry of motions, end quote, that actually did result in the Fifth Circuit issuing a temporary administrative stay of his removal. But it's all for naught. The Fifth Circuit denied the petition for review. Quote, a claims processing rule may be mandatory in the sense that a court must enforce the rule if a party properly raises it, end quote. The 30-day rule is that, explains the Fifth Circuit, noting that the Riley Court didn't necessarily actually hold that it's mandatory. So there's some wiggle room there in other circuits on this. Mr. Lau's petition for review was untimely because it wasn't received by the clerk's office in time. Oil asserted the untimely rule by filing a motion to summarily deny, asserting that 30-day rule. And the Fifth Circuit just held that it's mandatory if asserted. Pretty much the end of the story to the Fifth Circuit then, though there are 5 more pages. In those pages, the court primarily discusses the prison mailbox rule. Because after all, Mr. Lau is detained. And quote, under the prison mailbox rule, a pro se prisoner's pleading is considered filed when the document is placed in the prison mailing system, end quote. Seems like Mr. Lau was likely asserting this. But under Federal Rule of Appellate Procedure 25A2A-III, to benefit from the mailbox rule, a prisoner must include an affidavit or other evidence showing that it was timely deposited in a mail system designed for legal filing, or the circuit needs to decide to exercise its discretion to permit a later affidavit. Them the rules, apparently. Mr. Lau didn't do this. In fact, the Fifth Circuit isn't even sure whether his detention facility has a designated mail system for legal filings, which counterintuitively would then possibly preclude Mr. Lau from benefiting from the prison mailbox rule. In any event, there is no evidence that he timely deposited his petition for review, at least not sufficient evidence to the court. No affidavit. Even though Mr. Lau did include a certificate of service in his filing indicating timely filing and timely service on ICE. Why doesn't that suffice? Because to be an affidavit, you have to include the special language at 18 U.S.C. section 1746, which I literally copy and paste from every time I do affidavits. Explains the Fifth Circuit, without that last part specific to me. And for all of these reasons, it is the end of the line for Mr. Lau. And that is Lau v. Bondi.
And finally, matter of LTA from the BIA. This is a case about firm resettlement, specifically what counts as, quote, some other type of permanent resettlement, end quote. And this is one of those cases where the underlying asylum claim itself is strong, but the applicant still loses asylum anyway. Not because she isn't credible, not because she can't prove harm, but because of where she lived before she came here. The respondent is a citizen of Nepal. While she was a student there, she received 5 threats from Maoists after refusing to support them. In 2011, Maoists affiliated with the Young Communist League physically attacked her while she was organizing a meeting in support of the Nepali Congress Party. She was beaten with wooden sticks, lost consciousness, was hospitalized for a week, and needed stitches to her head. After that attack, she fled to India, where she lived for about 5 years. While in India, she worked as a hotel receptionist and lived in the country without any incident to herself. During that time, however, Maoists allegedly told her uncle back in Nepal that they would find her in India and force her to join them. Eventually, she left India and came to the United States, where she applied for asylum and withholding of removal. The IJ did make a series of findings favorable to the non-citizen. That the harm she suffered rose to the level of persecution, that her political opinion was at least one central reason for that persecution, and that the Nepali government was unable or unwilling to control her attackers. As a result, the IJ granted withholding of removal to Nepal, and DHS did not appeal that decision. But, despite all of that, the IJ denied asylum. Why? Because the IJ found that the respondent had firmly resettled in a third country, India, before arriving in the United States, and was therefore statutorily ineligible for asylum. Specifically, the IJ concluded that even without a visa or formal immigration status, the respondent had access to, quote, some other type of permanent resettlement, end quote, under 8 CFR section 1208.15. The respondent appealed only the asylum denial and submitted new evidence on appeal, which the BIA treated as a motion to remand. So the entire BIA decision really comes down to one question. Was the non-citizen firmly resettled in India? The BIA begins by walking through its 2011 decision in matter of AGG, which set out a 4-step framework for firm resettlement cases. First, DHS has the initial burden of presenting prima facie evidence of an offer of firm resettlement, which can be either direct or indirect evidence. Second, the non-citizen can rebut that showing by demonstrating, by a preponderance of the evidence, that no such offer was made or that she would not qualify for it. Third, the IJ will consider the totality of the evidence and determine if the respondent has sufficiently rebutted DHS's showing. And fourth, if firm resettlement is established, then the burden will shift to the non-citizen to show that an exception to firm resettlement applies. The BIA emphasized that an offer of resettlement does not require a path to permanent residence or citizenship. Instead, the regulation expressly includes, quote, some other type of permanent resettlement, end quote. And critically, that kind of resettlement does not require written documentation or any formal documentation at all. It can be shown through evidence that the non-citizen had legal rights normally given to people with official status, such as the right to work and enter and exit the country. With that framework in mind, DHS first had to present prima facie evidence that the non-citizen received an offer of firm resettlement in India. DHS didn't submit any direct evidence. The non-citizen had no visa, no residence permit, and no formal immigration documents from India. Instead, DHS relied almost entirely on the 1950 India-Nepal Treaty of Peace and Friendship, which provides that India and Nepal grant each other's nationals the same privileges regarding residence, ownership of property, participation in trade and commerce, movement, and similar rights. In plain terms, the treaty allows Nepali citizens to enter India without a visa or passport, live and work there indefinitely, own property, and engage in business and trade. DHS also submitted country reports showing that millions of Nepalis live and work in India lawfully, as well as Canadian IRB materials confirming that Nepalis are not considered illegal or unlawfully present in India. And the non-citizen's own testimony lined up with that evidence. She testified that she didn't need a visa to enter India, that she lived and worked there for 5 years, that she was not restricted from staying indefinitely, and that Nepalis can simply go to India and live and work there. The IJ found that this was sufficient to meet DHS's burden, and the BIA agreed. The non-citizen then raised a number of arguments to rebut DHS's showing that frankly make intuitive sense, but the BIA wasn't persuaded. She first argued that she was never offered any kind of, quote, enduring legal status, end quote, in India. But the BIA said that didn't matter because neither permanent residence nor citizenship is required for firm resettlement. And as the BIA explained, because of the India-Nepal Treaty, the respondent was not in unlawful status while living and working in India and could continue to do so indefinitely. The non-citizen also argued that India didn't even know she was residing there. Again, the BIA said that didn't matter. The regulations require only that an offer of firm resettlement be available, not that the government track the specific individual. What matters is whether India accepted Nepali citizens as a class of persons, and the BIA found that it did. The respondent also submitted evidence showing that Nepalis in India often face hardship, discrimination, poor housing, unstable employment, and while the BIA didn't dispute that reality, it emphasized that firm resettlement is about legal permission, not comfort. The focus is on legal rights, not quality of life. The respondent also argued that she lacked the right to vote in India and therefore could not have been firmly resettled there. But the BIA dispatched that argument quickly. Voting is not required for firm resettlement, and in many countries, including the United States, lawful permanent residents cannot vote. Based on all of this, the BIA agreed with the IJ that the respondent failed to rebut DHS's prima facie evidence of firm resettlement. The respondent also argued that an exception applied, that her residence in India was substantially and consciously restricted. She claimed she was still afraid of Maoists while living in India. But the BIA noted that she was never harmed in India, that there was no evidence that the Indian government couldn't protect her, and that unsupported assertions on appeal carry no weight, and that fear alone does not overcome firm resettlement. There were no government-imposed restrictions, the treaty rights remained intact, and private discrimination was not enough. The respondent also submitted new country conditions articles on appeal, one discussing Maoist activity in India, and another discussing tensions between Nepal and India, and a general feeling among Nepalese that they are not treated equally under the India-Nepal Treaty. So the BIA treated this as a motion to remand. But the board denied remand, holding that the evidence would not change the outcome. The articles showed that the Indian government was taking steps to address Maoist activity, and the articles did not demonstrate any government-imposed restrictions on Nepali residents or employment in India. So where does that leave the non-citizen? The BIA dismissed the appeal, affirmed the asylum denial, and denied the motion to remand. The grant of withholding of removal, however, remains in place for the non-citizen. But the real impact of this case is how aggressively the BIA defines firm resettlement. This non-citizen had no formal legal status, no paperwork, no individualized offer. All she had was indefinite legal permission to live and work by operation of law, through a treaty. For practitioners, this is a major warning sign. If your client lived long-term in a third country with open borders, treaty-based work rights, or nationality-based residence privileges, you cannot treat that as a footnote. The BIA is telling us that if a non-citizen had somewhere else they could legally stay forever and did indeed stay there for a time, that alone may be enough to bar asylum because of firm resettlement, even if the non-citizen never thought of themselves as resettled at all. And that was matter of LTA.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.